This is Colin O'Keefe here for LXBN TV. The Supreme Court heard oral arguments this morning in a case that could shape the future of television in a lawsuit between ABC and traditional broadcasters and streaming television startup Aereo. Joining me now to recap what happened is someone who was actually on hand for the oral arguments. That would be attorney Kevin Goldberg with Fletcher, Hield & Hildreth, an author on the firm's law blog. Kevin, first, let's start with just the basics. What are your initial impressions of what happened at the oral arguments? What did you see there today?
Well, it's interesting. Sometimes you go up there and an attorney can definitely lose a case. That did not happen today. Both of the attorneys for each side, in fact, there were three attorneys arguing. There was an attorney for the broadcasters, an attorney for Aereo, but also the Solicitor General arguing, and they did a bang-up job. I'm not sure anything got easier based on what we saw today, and I think the justices are definitely struggling with some difficult questions. At the same time, it's very interesting because how they answer those questions could make the decision 9-0 one way or the other. So they were really interested not just in the future of broadcasting, but the future of things like cloud computing. And that's really, I think, going to be at the heart of this matter and could determine which side ultimately wins. The other questions arising seem to be about whether Aereo was a cable company or not. That was actually the first question out of the block by Justice Sotomayor, and not one that anybody is focused on the way up. I think people who are familiar with this case seem to believe that Aereo is clearly not a cable company as defined and as implemented by the Federal Communications Commission, but she seemed really interested in this. And to me, that indicates that she's a little skeptical that they are, that they can be found legal in some way, because to do so, they'd have to be a cable company. So I think there's a couple issues in there that were very telling that we're going to have to see how the court comes out on them.
It's going to be really interesting to see. The necessary caveat, of course, with these Supreme Court oral arguments is that though sometimes they can mean a lot, other times they can mean relatively little, and forecasting based on them can be a bit foolish at times. But having said that, let me ask you, the Swami of the law blog, did the Supreme Court justices give any indication about which way they might be leaning with this case?
Well, I've said before that I thought that Aereo got out of the blocks quickly, obviously winning at the United States District Court for the Southern District of New York, having that decision affirmed for the United States Court of Appeals for the Second Circuit, and that is the case before the Supreme Court today. They've, however, lost a couple times, as has their sort of counterpart, Film on X. So it's not so easy as to say that they've been, straight across the board winners. And I think we're definitely seeing the broadcasting side of the arguments being accepted more and more and more. And so you almost say that the broadcasters have had a good finishing kick. I actually feel like the broadcasters are in good shape here. What's really interesting to me is the court stayed away from any real discussion of whether the preliminary injunction should be upheld or not. So I think they're looking at a broad pronouncement. And again, going back to what I answered in the first question, or what I discussed in my answer to the first question, the ramifications for other technologies. And to me, we had Justice Breyer asking a lot of questions. He's sort of the big-time technology guru on the court, and he's asking a lot of questions as to how he can write this case in a way that doesn't upend cloud computing. So to me, I'm leaning toward looking at maybe not a 9-0 decision, but a pretty strong decision that says Aereo is violating the broadcaster's copyrights, but we're not going to write this so far as to say it's going to tear up cloud computing. So it's kind of in this middle ground to me. And I think if Breyer can be convinced that he can write that opinion that way, that's what I'm leaning toward. It may not be everybody onto the same rationale, but I'm my gut right now, coming out of here now an hour ago, is that the broadcasters have to be feeling okay if they can get them. Now, as I said, if Breyer can't be convinced, I think that Aereo can be found to be violating the Copyright Act without also finding that cloud computing violates the Copyright Act. It's a whole different story, and it could go literally 9-0 the other way, because I do think people are very worried about that, about the future of technology being implicated by this case.
It's going to be fascinating to see because, as you mentioned and alluded to there, the Supreme Court oftentimes likes to focus its decision and its opinion very closely on the case at hand and not have it get too broad. So I would expect to see something similar, but we really don't know which way it's going to go within the context of that. Once again, that was Kevin Goldberg of Fletcher, Hield & Hildreth. Be sure to check out their publication and everything they have going on around this case. It is at comlawblog.com. Thanks for joining me today, Kevin.
Thank you, Colin.